So a few drop-down points on this one. It's only appropriate in some cases. So only where there's a clearly large disparity in the contributions. Next point, it's actually useful to consider even if there's not a family loan involved. So think about, say it's your son and his partner, and your son has led a monastic lifestyle so that he's got 60,000 to put into the purchase, but his partner has had a good time, she's only got 15,000. So your son done the hard yards, worked hard, not spend, made sacrifices, putting in more, 45,000 more. Why shouldn't they consider using a simple contracting out agreement like this to protect that extra contribution? It's worth thinking about. Next point I make is that a simple contracting out agreement needn't be complicated or expensive. And I know we all have our moments. I've produced complicated agreements. I've done expensive agreements. But in the situation I'm talking about here, of if you are forced to gift, then maybe a very simple agreement. Don't try and cover a whole lot of other stuff that doesn't need to be done. So there's a simple wording, as you'll see on this slide. And obviously this is just one part of the contracting out agreement. There's all the other usual boilerplate text that lawyers like to put in these things. So you can see there in paragraph A, it says a sum of 75,000, that's the imbalance in this case, 75,000 shall be paid or credited as the case may require to Sam as her separate property in priority to all other claims or payments. And then, clause B, the balance of the parties' relationship property shall then be divided in accordance with the provisions of the Act, which for most people might be 50-50 for the family home. So you can see from this, two short clauses, a very nice, conceptually nice way of trying to protect money that's gifted to the young couple and keep it free from risk. So my next slide talks about some other ideas to consider. The first one is the idea of co-owning agreements with parents. Prior to the Bright Line test going to 5 years, this was quite a popular option, and there's a number of variations with it. It could be that the parents go on the title and the young people don't, and then elements of loan and gift are detailed in a private family document. I've seen others where everyone goes on the title with agreed timeframes and formula for the parents to be brought out at a future time. So there may be elements of gifting, there may be elements of lending. It's a nice hybrid way of gaining protection and control. Better also than parents giving guarantees, which is something that happened a lot in the past. The next idea to consider, of course, is clever things with trusts. Now, I'm not going to tell you what the clever things might be because there are so many permutations and circumstances that might come up. As a general rule, I think the greater the sums of money involved, the more clever the scheme might need to be. So, for example, with a large farm, the young people who might be acquiring the farm, they're not going to be worried about home start loans or eligibility to withdraw KiwiSaver. Those are minor in the scheme of things. And often trusts count you out. If you expect to buy in a trust, you sometimes can't get your KiwiSaver withdrawal or your home start. It's worth checking with the mortgage advisor. But so the bigger the number, the more likely you might be thinking of a trust. And of course, that's one of the standard tools we have in our toolbox. The next one I just want to note is that we have seen people doing what I would call a bet both ways. Many families just take the view, well, let's just sign what the bank wants. But as a family, we're going to treat this as an IOU. I think that happens more than we think. Often families do these things behind the scenes. We don't know quite how it's going to work out. I don't know. Maybe some interesting litigation later. So next slide is my summary about gifts to families. The first point is that there are some good options, and you can consider and think about those as alternatives. We've talked about the acknowledgement of debt if the lender will wear it. We've talked about a simple contracting out agreement. We've talked about co-owning agreements. So it needn't be a straight out gift. There are lots of permutations and variations. The next point is that each option, whichever one you look at, it must be tailored to suit. There is no one solution that fits all the issues that are come your way. So, for example, the simple contracting out agreement, which I mentioned, that only applies if there is a disparity. If the young people have roughly equal contributions because one of them has received a gift from the parent, well, not much is going to be achieved by using the contracting out agreement in that case. So you've got to think carefully about it. The last point here is that teamwork is important, and we need to have everyone involved in giving their views. So the mortgage broker, I've mentioned them quite a lot. Financial planners, of course, they've got to be looking at affordability. A lawyer and possibly accountant. And the best solution is one where each of us gets to have our contribution. Now, I want to talk briefly about gifting and the residential care subsidy. Other speakers will cover this in part, but I think we're all reasonably familiar with what the current rules allow. So there's gifting of $6,000 per year in the 5 years prior to your application being made. Prior to that, there's gifts of $27,000 per couple. And as noted there, it's important not to lose sight of past excess gifting. This is the deprivation I referred to before. With quite a few clients of mine, we have had to do very careful reviews. Often clients might think things are fine, or the gifting program was a great idea, or why aren't we doing more gifting? Sometimes when you look at the assets which clients have built up since the asset protection scheme was started, and maybe adding back some excess gifting, you might think, oh, is there any point? And so the review process, very important. If you are gifting, don't just keep doing it year after year. Be aware of the past gifting and be aware of the current rules and what are you trying to achieve. The last point here is about wins and the checking of applications. Often our clients are dealing with wins and dealing with the application for residential care subsidy. It can be a bit of a nightmare. My experience is that wins are very clever at asking the right questions and doggedly insisting that they get the right information. And my suggestion and recommendation is that we don't try any clever tricks because they just don't work. The best thing is to have a full set of information and your clients well informed and well prepared so that they know whether the application is likely to go through, or if it's not likely to go through, they're aware of that possibility. So to conclude, gifting with a warm hand, I think it's a nice idea, but we need to do it carefully and in a planned way, and we need to be aware of the alternatives to an outright gift. Next point is for gifts to family, we need to think about treating them as loans and the other options that I've talked about. And lastly, for residential care subsidy, we need to do a careful review. Actually, is there any point to this gifting, and is it ever likely to work? So there's another perspective on gifting with a warm hand. Nice idea, but let's do it in a careful and planned way. Thanks very much.